Hello, we've opened the webinar for attendees to join, so we'll allow a few minutes for that to happen. This is Scott Horton. As you're joining, I'll be your presenter today. You should be able to see the cover slide for today's presentation on auditing your New York worker classifications. And you should have access to a chat window where you'll be able to ask questions during the presentation. Looks like people are filtering in. Got this opened just a couple minutes before the start time. We might give an extra minute as people are still getting logged in. Hello, everyone who is logging in. Thank you for joining us for today's presentation on auditing your New York worker classifications. I'm going to give another minute or so just to make sure everyone can join us who is trying to do so. All right, we're about to get started. Just going to give a little bit more time because I can see that people are still logging in. Again, make sure you can find the chat window where I have typed an introductory message. So if you can see that, then that's where you'll be able to ask questions that I will answer during or more likely at the end of today's presentation. I'll go over all the logistics again in just a minute and we will get started. Okay, it looks like a large number of people have been able to log in. I'm sure we'll have a couple more join momentarily, but I'm going to go ahead and get started with a few of the logistical details. So I aim for about an hour on this presentation. I will have a question and answer segment at the end and try to stay on to answer all the questions that are asked. If you do have a question as we're going in today's presentation, please type it in the chat window. If you do that and I see it, I may answer it along the way, but more likely I will circle back to that in question and answer, just so we can make sure to keep on time for everyone who needs to leave at the end of the presentation itself. But obviously encourage everyone to stay on for questions and answers. Just keep in mind that if you ask a question, there is no attorney-client privilege to your communications in this forum. So I will answer the question as generically as possible. If you have a question specific to your organization, then you may be better off asking that offline. Today's presentation on auditing your New York worker classifications, technical violations, create material liability is designed to help employers with people working in New York to classify their employees along various uh, axes. And I will go over that in just a moment. My name is Scott Horton. I am the owner and founder and attorney with Horton Law PLLC based in Orchard Park, New York, and I'm happy that you decided to join me for the next hour. Big question before we get into the substantive details is, why does worker classification matter? I don't think this is Necessarily a hard question, but ultimately, I think it's a question that comes down to a pretty straightforward answer, and that answer is money. Money meaning various different things. Classification issues are very important to government agencies who like to receive their uh, taxes and other mandatory payments. They do so through employment or payroll tax withholdings from employers. That includes employee and employer contributions. They don't get those same withholdings for people who are not classified as employees. It also can mean money for the employees. It can cost companies more or less, whether they have classified someone as an employee or not. And also pertinent to this presentation is the downside of misclassification, and that is if you have not classified your employee properly in certain ways and then treated them the way the law requires someone of that classification to be treated, then your organization could eventually face a claim of some form of violation related to wages, for example, and be obligated to pay not only certain lost wages, but additional penalties as well. So the bottom line is it would be better to get it right up front than to face claims and eventually be required to pay more. So that is what today's presentation is going to aim to help you do. And that is get those classifications right up front. So here are some of the different classification issues that I'm talking about today. First, there's the employee versus independent contractor classification. This is, in a lot of respects, sort of a threshold issue. Again, if someone is an employee, that creates various additional rights and obligations that your organization needs to attend to, whereas independent contractors have comparatively fewer rights vis-a-vis or an entity that might otherwise be an employer, but not in that situation their employer. We'll get into that in more detail. Somewhat related to the question of employee versus independent contractor are special issues involving students, interns, and volunteers. In some cases, students and interns might qualify as employees, but their classification as a student or intern might nonetheless have material implications. If someone is a volunteer, then essentially by definition, they're not an employee. Whether that person is an independent contractor or not is, probably an academic question, but in a sense, they could be deemed an independent contractor in the sense that they are doing work as a non employee. In that case, they might just be theoretically an independent contractor who's not getting paid anything. So we'll explain how all of those issues relate and compare them. Then, once you have someone who is an employee, there's the important classification question of exempt versus non exempt, which has implications for both minimum wage and overtime purposes. And then there is the usually less um, considered question of classification related to pay frequency under New York law. Private employers, that means non governmental entities, have certain parameters by which they must pay their employees in a certain amount of time. Those requirements are increasingly important because of some recent cases in litigation in New York State that have decided that if employees do not get paid as frequently as they should, then there may be extensive penalties to the employer. We'll talk about that more as we get to that segment of the presentation. And finally, to sort of wrap this up, once we explain a lot of the different classification issues, I want to summarize some related notice requirements under New York law. So, one of the uh, first places to look is again at the question of whether someone is an employee in the first place. There's a lot that could be said about employees, a lot of employment law classes that you may have taken even in college or grad school or online courses or trainings go all the way back to the master servant relationship. I don't think it's really necessary or practical to go all the way back that far. The bottom line in today's world is that if you have someone working for individual or organization, you then have to decide whether that person is or isn't an employee. Usually, if they are an employee, that means the employer is controlling not only what work product is supposed to be produced, but also how it gets done. There's a lot more to be said about that, and we'll touch on it as we go forward. But really, it's the how and the details of the work that the employer controls, where a non employer wouldn't have as much say over that. They may hire someone just to do a project and then expect the project to get done, but the details are left to the individual. In that case, you may have an independent contractor relationship. But assuming someone is an employee, we're usually noticing that their compensation is framed in the form of an hourly rate, a certain amount of money per hour with or without overtime, where that's applicable, or on a salary basis, a certain amount of money guaranteed each week. You can have a combination of hourly and salary rates for the same individual, and any individual may also or instead be paid on a commission bonus. Sometimes you have someone with a fixed salary or hourly rate who's also eligible for commissions based on sales or some other contribution to the business. And although technically distinguishable from commissions, a similar concept would be bonuses, where they're usually a bonus is different than a commission in the sense that the bonus might be either completely discretionary or based on the overall performance of the company or a department or division of the company, where commissions normally would be thought of to be more directly based on the employee's personal performance. Once we have an employee who's being paid on one or more of those bases, again, as I alluded to earlier, the employer is expected to withhold and deposit income, Social Security, and Medicare taxes, potentially among other tax like issues. So, again, this is what the government agencies like to see. Usually more reliable to expect the employer to bear this burden of getting all this money over to the government than to rely on a bunch of individuals to do it themselves, although there are many individuals who are responsible for making their own tax payments and not just on an annual basis. So self-employed and independent certain independent contractors have to file as much as quarterly estimated tax payments. Those things are not required in the straight employee employer setting, which is something of a benefit to the employees and not always that much of a burden to the employers. But there are situations where there's a reason that people would prefer not to have taxes withheld directly by the organization they're working for, or vice versa. So again, in this situation, after the employer withholds these taxes and pays them over to the government, they then issue a W-2 form to the employee so the employee can file their annual tax return. Beyond those tax issues, there are certain employee benefits that may be offered. Some might be required by law, for example, unemployment insurance, disability, paid family leave are required for many employees in New York State, with some exceptions. There may be other insurances such as health insurance or life insurance or additional disability insurances that a company offers their employees. There are various retirement vehicles, whether they be traditional pensions or 401k or 403b type arrangements. And then benefits also include things like time off, like sick leave, now required for private employers across New York State, or vacation or PTO that companies offer on their own. So, again, employees may or may not be eligible for all those things, but they are more likely, much more likely to be eligible for them than non employees, including independent contractors. So, what do I mean by an independent contractor? Ultimately, it means someone who's not an employee, but is nonetheless performing services for someone who otherwise might be considered an employer. So, whether you have any employees or not, if you hire someone to do work for you, uh, they could be an independent contractor, among other things. The independent contractor relationship usually, again, means that the hiring party has the right to control the result of the work. In other words, um, I want at the end of the day a work shed on my property. How it gets built, who hammers the nails into the wood, and which saw is used would be up to the independent contractor. Obviously, there are more complicated issues or scenarios that arise in the distinction between employees and independent contractors that we will talk about. But again, the one of the key distinctions is the contractor usually controls the how rather than just the what, which is what the employer or hiring party, wherever you want to call the other party in the transaction, determines. Compensation is usually in the form of a fee rather than a wage. It can be a fee based on hours worked, which is not even uncommon in my business as an attorney, of course. So it's not that it can't be hourly, but you wouldn't consider normally that you're paying an outside attorney an hourly wage. You would consider it an hourly fee. So perhaps it's a semantic distinction, but nonetheless one that is made and recommended. If you say you're paying someone on a wage or salary basis, it's certainly going to suggest an employment relationship. You pay the independent contractor their fee, and then if the payment is large enough, it normally needs to be reported on a form 1099 instead of a W-2. So the government knows that this payment was made, but they don't expect the paying party in that situation to withhold taxes. They will just expect on the other side, the party that receives the payment, to report their taxes properly and pay what is due. Again, an independent contractor is distinguished from an employee, is typically not eligible for benefits and usually should be responsible for their own taxes and insurance coverages. All right, the next several slides here are going to address various tests for determining whether someone is an employee or an independent contractor. I should point out, I didn't earlier, that at the end of this presentation, I will give you a link to these slides. So if you want to have a copy, they'll also be emailed to you if you're a registered participant for the webinar. So don't feel like you need to take all of this information down, especially what's on these next few slides. I just need to identify that there are these various tests and explain what that means practically. Bottom line is there are many different laws, New York State and federal, that address employees, and each law potentially could have a different definition of employee, and whichever entity, whether it be an administrative agency or the courts, that interprets and applies the law in various situations may use a different test to determine whether someone qualifies as an employee or not. So I find it relatively impractical to worry about a specific test or even a couple specific tests. I try to just sort of lump the analysis more together, which I'll explain after I identify the various tests. And this is not necessarily an exhaustive list of tests, but the bottom line is that different agencies do use different tests. This common law test is more derived from court rulings over time, and this is what is used by the IRS these days. At one point, the IRS had a 20-factor test, but they relatively recently decided that that was too cumbersome. So now the common law test has certain elements that it considers. There's an economic realities test that the US Department of Labor adopted a couple of years ago at the end of the Trump administration. Then the Biden administration came in and clearly doesn't agree with the economic. I'm sorry, I got that backwards. The Trump administration put in a 5-factor test. The economic realities test is the Biden administration's preference at this point in time. So the US Department of Labor is currently trying to figure out what its test for what an employee is under the FLSA. And the 5-factor test from the Trump administration is technically still on the books, but the Department of Labor has now proposed a shift to the economic realities test. Finally, there's ABC tests that are commonly mentioned. ABC tests are basically very restrictive 3-factor tests that are used in certain states and in New York, specifically for the construction industry so far, but there's a movement to extend the ABC test beyond the construction industry. Again, most of these tests apply in specific situations, and various tests may apply to the same individual, just depending on who's asking the question. In other words, is this a question of whether the person is an employee under the Fair Labor Standards Act or the New York minimum wage laws or a state or federal employment discrimination law or for tax purposes? And again, rather than trying to actually apply a bunch of different tests, I'll give you some guidance on how to address the issue generally, because it's relatively unlikely that you want to take a given individual and treat them as an employee for some purposes and an independent contractor for others. The common law test, which is what the IRS currently uses and what the court roughly apply in various other situations, is broken down into these 3 factors: behavioral control, financial control, and the type of relationship. So behavioral control addresses what people are doing, so when they do it, where they do it, who supervises the work, if anyone. And then financial control addresses things like who owns the equipment that's being used, the tools and instruments of production, who stands to make a profit or loss off of the work being done. And if it's an outside party that's coming in to do the work, do they have a financial upside or downside as to how fast they get the work done, for example? And then the type of relationship, this goes down to more pragmatic questions, including, is there a contract in place? I think it's always a pretty good idea if there's an independent contractor relationship that you have some sort of written contract or agreement to memorialize that intent between the parties. The type of relationship would include things like the permanency of the relationship. Has this person been doing the same job for this organization for an extended period of time? If so, that might undermine the independent contractor characterization, but not necessarily. Overall, this is a totality of the circumstances test. It is not that any one factor is dispositive. And that is a general theme of some of these tests, but it is not universally true of all of the tests. Then we have the economic realities test that is currently being pursued by the US Department of Labor as the binding test under the Fair Labor Standards Act. This is based on the proposed rule. These items are six factors that are specifically listed, and then the rule also says that they would also consider additional factors if relevant in a specific situation. Again, the key point here is this is another totality of the circumstances analysis. No one factor is supposed to be determinative of whether a person is an employee or not. I'm not going to read all of these, but you see overlap from what I was just discussing under the common law test. One other factor is the skill and initiative factor, and this pertains to the concept that the more specialized the services are, perhaps the more likely that someone is to be considered an independent contractor. But that's not to say that there aren't very specialized workers who qualify as employees. The five-factor test, again, this is the one that technically currently in place under the Fair Labor Standards Act, but is likely on its way out. The five factors here somewhat overlap with what we've seen in the other tests. The critical distinction is that with this five-factor test, the Department of Labor specifically identified the first two factors as being more determinative than the others. So the nature and degree of control over the work and the opportunity for profit or loss are supposed to be emphasized in this five-factor analysis. That is probably a relatively unusual approach, but one that um, I think the previous Department of Labor leadership expected to give businesses greater leeway in identifying workers as independent contractors. Finally, we have the ABC tests, and these are in place at different scopes in various jurisdictions across the country. Again, in New York, currently it's limited to the construction industry. This is intended to be a very restrictive test, restrictive in the sense that the default is always that someone is an employee, but if all three factors, A, B, and C, are met, then someone qualifies as an independent contractor. Uh, A, B, and C don't represent anything in particular. It could just as easily be the 1, 2, 3 test. It just happens that they're labeled A, B, and C. A says the worker is free from the employer's control or direction in performing the work. Again, the employer, for lack of a better term, determines what ultimately is going to be produced or what service is going to be rendered, but how it's done is up to the worker. B, the work takes place outside the usual course of the business of the company and of the site of the business. So this primarily means that it has to be a different type of work than what the employer involved usually does. So if you run a plumbing company and hire a plumber to come in and work with your team on a construction project, then you probably have to consider that person an employee independent of anything else because of this B component to the ABC test. Whereas if you run an office based business and you have a problem with your plumbing and hire a plumber to come in, that work is then outside the usual course of the business that you're doing in those offices, so you can meet that B element. And C, customarily the worker is engaged in an independent trade, occupation, profession, or business. What the real key hallmark of independent contractor analysis often tends to be is whether the worker has their own business separate and apart from working for the employer. So if they have their own corporation or LLC, or either even if they're a sole proprietor, if they are readily seeking work from various companies and have marketing initiatives, and they keep their own books and that sort of thing, then that's going to be helpful to show an independent contractor relationship under the ABC test. That to some extent basically becomes a requirement. Exactly what that requirement means is a little bit more complicated, but it somehow would have to be met under an ABC test. So taking all of those various tests together, I kind of boil this analysis down into these three questions. Not to say I wouldn't ask different questions or more questions in specific situations, but rather than get hung up on which test applies, unless you're subject to the ABC test, in which case you have to apply that test specifically. But under the more general test where they apply, which is true for most employers in New York State, the first question I'd ask is the worker in business for themselves? A couple different ways this can happen. Again, if the plumber's coming in, they may work for a plumbing company. If your business doesn't do plumbing and they're just there to, fix some pipes in your office or factory, then, there's a pretty good chance that they're not going to be an employee. Whether you even care whether they're classified an independent contractor in that situation or not, they're just a service provider coming in. But then you shift to a little bit closer call. Think of a consultant, for example. Well, if you hire a consultant to come in and work on a project, whether it's on a team of your employees or not, a big question then becomes, again, are they in business for themselves? Do they regularly perform this type of service for other companies, or are you just hiring them to do this type of work for you? In which case, it's going to look more like an employment relationship. The more this individual has set up their own business and markets themselves, and has set of books and handles their accounting, the better. Kind of related to that is the question of, can the independent contractor outsource their work? So if you just are saying you particular person have to do this work, that's going to look a little bit more like an employment relationship than if you can say you contractor get this work done, and if you need to hire people to do it, then you do that. They're your employees, not ours. I alluded to this next question already. Do they offer their services to the general public? That certainly helps, and it's often a question that I end up working through with clients. It doesn't necessarily mean they have to simultaneously be doing this work for multiple parties. Again, to use the plumber analysis, plumbers are probably working for multiple different customers, if not in the same day, in the same week, and certainly as a general matter. More specialized consultants may be focusing on one company at a time, and they may only be working for you in a given day, week, or even longer period. But the question is not necessarily one of current exclusivity as much as, when this job is over, are they moving on to the next one? Or is it a situation of when this job is over, then they don't know what they're doing next and it may or may not be in this field? And then finally, an important, very practical question is why not treat it as an employment relationship? The employment relationship is pretty much going to be the default if you're asking this question. And there has to be some reason that you don't want to treat it as an employment relationship, or that the party you're trying to hire doesn't want it to be an employment relationship. And if you ask that question, sometimes you run across a answer that makes it seem pretty questionable to try to force it into an independent contractor arrangement. If, for example, the employee or worker was trying not to be an employee because they don't want taxes withheld, that might raise a red flag. On the other hand, if the company wants it to be an employment relationship because they don't want to offer employee benefits, that might be a rational consideration. But if the only difference between the person that you want to treat as an independent contractor and some other people that work for the company is that some of them get employee benefits and others don't, then that's probably a good sign that that person wouldn't really be considered an independent contractor down the road. Not to say that that can't be a motivating factor for the nature of the relationship, but it is certainly not a good dispositive factor, and you would want to make sure everything else looks right, especially under these other two questions above. Okay, before we move on, I just want to ask a quick question that you can click simply to get a little bit of idea of what types of organizations you work for or represent. Basically, this comes down to, do you work for a for profit company, a nonprofit organization, or a governmental entity? While these independent contractor and employee distinctions apply pretty universally across those different types of organizations, some of what we're going to talk about next is different depending on what type of organization you're with. So right now it's coming in at a relatively even split between for-profit and nonprofit. At the moment I'm seeing exactly a 50-50 split. Just shift. I know we did have some folks from government entities, towns, cities, or what have you, signed up for the webinar. None of them are at least responding. But the majority, it looks like, are in the non-governmental sector and very evenly split of for-profit and not-for-profit, which is not that surprising to me. And I will make the distinctions going forward. I think it's important for all of you to understand some of these distinctions, because especially if you're looking into these issues down the road, you want to be careful not to read something that is intended to apply for a different type of organization than what you are. Um, Sorry, I was slightly ahead of myself on the independent contractor piece. Again, as I said before, you should make sure you have an independent contractor agreement, and these are some of the items that you want to include. Again, the more you can make it clear that you're hiring an independent business to come in and provide some sort of specific service that your company doesn't otherwise handle, the easier it will be to prove an independent contractor relationship. All right, now towards the issue where there's some distinctions that I mentioned. And again, generally here I'm speaking about New York specific workplaces. I am addressing where relevant federal laws, but I'm otherwise completely ignoring state laws and local laws from outside of New York State. So if you have people working outside of New York State, be careful to consider any local laws or state laws in those settings. But within New York State, this information should be relevant. So, for profit businesses generally must pay all employees for their work. Usually that means minimum wage. It may or may not mean certain statutory overtime. It definitely means whatever you've agreed to pay them. But the bottom line is a for profit business, the presumption is that the employee has to get paid. In some cases, students might not be employees. Under the Fair Labor Standards Act, there's something called the primary beneficiary test, which I'll go over, which determines whether a student slash intern can be considered exempt from the category of employee. But for most of you, you would need to also comply with New York State laws, and the New York State laws don't necessarily follow this primary beneficiary test exactly. I mentioned most of you, so the New York State laws that I'm talking about generally don't apply to government entities. None of you identified that you are a government entity, but I'm sure some of you either listening now or who may get this information later are working for towns, cities, um, school districts, etc. So it's important to know that a lot of this New York State distinction um, applies differently whether you're a government entity or not. It also applies differently whether you are for profit or not for profit, as I'll explain. The federal primary beneficiary test, which again generally applies to all of you, it just may not be the only test that applies to all of you, looks at fundamentally the extent to which the intern is being the primary beneficiary of the relationship, or the company they're working for is being the primary beneficiary of the relationship. First of all, if there's an expectation of compensation, then it is most likely going to create an employment relationship under the FLSA. If there's no expectation of compensation of the intern, then you can move on and have to do analysis as to the extent to which the internship provides training that would be similar to that given in an educational environment, which of course can include hands-on training. The extent to which the internship is tied to a formal education program, ideally shown by the receipt of academic credit, although that's not necessarily required. Some additional factors based on the timing of the work that it would accommodate the academic calendar. Usually, these types of internships are limited in duration, and there has to be uh, no real expectation of a paid job at the conclusion of the internship. Otherwise, the guarantee of future pay could essentially create the concept that the work is being compensated and therefore they're an employee. The other factor that I skipped here, the second to last one, is important for various analyses that we're going to discuss here in the next few minutes. And that is the extent to which the intern's work complements rather than displaces the work of paid employees while providing significant educational benefit to the intern. In other words, if you bring someone as a student intern in to do the same work that another regular paid employee is doing, then you probably should be paying the intern and treating them as an employee. But if the intern is maybe doing research that the company normally otherwise doesn't do, and the research is going to be generally instructive for the intern with relationship to the industry or occupation that they're pursuing and just happens to be um, incrementally beneficial to the company that they're doing the research for, then you may still be able to have an unpaid intern under those circumstances. Again, these are highly fact specific questions, but the threshold issue is usually, is the intern being paid? If so, they're an employee. If not, consider all these other factors to determine whether you can exclude them from the minimum wage requirements under the FLSA. New York State gets a little more complicated. And again, if you're not a governmental entity, you most likely are subject to both the FLSA and state minimum wage and overtime requirements. And with respect to the state minimum wage and overtime requirements, you should make sure that you are satisfying New York State in addition to the FLSA. New York State's intern criteria basically takes the federal criteria and then adds several more on top of it. For example, New York State says the activities of the trainees or students do not provide an immediate advantage to the employer. On occasion, operations may actually be impeded. An employee you wouldn't normally think of as impeding the employer's operations, but the idea here is that there's really something of a burden to the organization to be showing the intern how things work more than the intern doing something that is going to lead to profit for the business. And I'm not going to read all of these specific requirements. But New York State, again, requires that there be no employee benefits provided in addition to no compensation. There's a requirement that any clinical training provided in the internship is performed under the supervision and direction of people who are knowledgeable and experienced in the activity. That's probably normally going to be true, but that is an additional express requirement that New York State imposes. They also require a specific notification that there will not be any wages paid in the internship, and that the screening process for the internship and ads and postings demonstrate that the internship is not the same as employment and that there is some sort of educational component to the internship. Again, critically, this is all if you're trying to have an unpaid student intern in a for-profit business in New York State. Now I'm going to address nonprofits here because nonprofit organizations, including government entities and private nonprofit organizations, may have unpaid volunteer workers. Under the FLSA, sorry to be bouncing back and forth between the state and federal laws, but again, most of you have to satisfy both. Under the FLSA, a nonprofit organization can have unpaid volunteers if their work is for public service, religious, or humanitarian objectives without any contemplation or receipt of compensation. So if you're a nonprofit and people agree voluntarily to work in a public service, religious, or humanitarian manner and don't expect to get paid and in fact are not paid, then they are exempt from minimum wage and overtime requirements under federal law. For the student aspect of this, students, trainees, and if students or trainees are interns and they're working for the nonprofit organizations, they may be exempt from New York State minimum wage and overtime, even if they're paid. In other words, if you paid a student intern in a nonprofit organization $10 an hour, they could still be exempt from New York State minimum wage and overtime requirements. So they're not technically a volunteer, but as long as they're a student in an actual academic program, they would not be subject for New York State minimum wage and overtime. The problem then becomes, assuming you're also subject to the Fair Labor Standards Act, which would be true of a nonprofit organization generally, but maybe not a really small nonprofit based entirely within the state of New York that doesn't conduct any interstate commerce somehow. The receipt of compensation of $10 an hour could invoke and probably would invoke the Fair Labor Standards Act requirements, which then means you'd have to pay them federal minimum wage and overtime. The $10 an hour in that example would exceed the $7.25 federal minimum wage, but if the person then worked over 40 hours in a week, you'd have to pay them time and a half. That would be $15 an hour for overtime under the federal law, even though they're exempt from New York State minimum wage and overtime on the basis that they're a student working for a nonprofit organization. Now, to continue the complexity, non-student volunteers are subject to more restrictions under New York minimum wage and overtime laws. And the other note that I want to have is that employees of nonprofits, so people who are paid to work for a nonprofit organization, can volunteer for that organization to do completely different types of work. For example, if you're an accountant for a nonprofit organization and you want to help run a fundraiser, like literally standing at the table, handing out materials to people who come by during an event, then you could volunteer your time to do that. But you could not work as an accountant for a nonprofit organization for 40 hours and agree that once you work beyond 40 hours, any additional time would be on a volunteer unpaid basis. So I mentioned that New York State has additional restrictions on volunteers. So again, this is nonprofit uh, in the non-governmental situation, because the government is not subject to these New York State minimum wage and overtime requirements generally, but private nonprofit organizations can have unpaid volunteers as long as the volunteers don't do these things. Most notably, they can't replace or augment paid staff doing the work of paid staff. So if you have, we'll just use the same example, uh, a paid accountant in your organization who normally handles the books, and you want to have a volunteer come in and help them out with their work, then that volunteer is probably replacing and or augmenting paid staff and therefore could not be unpaid and would then become an employee who is subject to state minimum wage and overtime requirements. There's different specific restrictions here, not most of which are surprising. One thing to note is that you can't require a volunteer to work certain hours. And there's going to be some flexibility in what that means. It probably can't mean, the 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 organization is open from 8 to 5, so you have to work between 8 and 5. The point is, you can't require someone to work every hour from 8 to 5 or every hour from 8 to 3. And if they do come in at 8 and they were supposed to stay till 3 and want to leave at noon, there's no penalty for doing that. All right. So, with the rest of our time here, I want to get to the last big topic of minimum wage and overtime. We've talked at length really about whether someone is an employee or not, and whether that means they're subject to minimum wage and overtime requirements. Again, unfortunately, I have to keep alluding to distinctions between federal and state law because many of you have to comply with both. The big question here is an employee exempt or non exempt? Non exempt employees have to receive minimum wage for all hours worked, and then they must receive overtime at time and a half for hours worked beyond 40 in a week. This is true under state and federal law. That's not to say that you can't agree to pay overtime to people who are exempt. And it's not to say that you can't agree to pay overtime in other circumstances, like for working over 8 hours in a day. It's just to say that these are the statutory minimums. If someone is exempt, that means they're excluded either from minimum wage and or overtime requirements. Key point there is it is possible for an employee to be exempt from overtime, but not minimum wage, or potentially vice versa. Most exemptions cover both, but not all of them. And there's some interesting distinctions between federal and state law in that respect. And it's fair to assume in all cases that it's the employer's burden to prove that an exemption applies. If the employer can't prove the exemption applies, then the employee would be deemed non-exempt. Here are some key exemption facts. I'm going to show the different tests for exemptions, but not get into too much detail on them. But I want you to have that material. But at a higher level, note that non-governmental employers must comply with the FLSA and New York minimum wage laws. Public employers, this is government entities, are subject only to the FLSA, with the very limited exception of non-instructional employees in public school districts. So cafeteria workers, bus drivers, custodians in public schools are subject to New York State minimum wage and overtime laws. Any employees of towns, villages, cities, counties, etc., are not subject to the New York laws, but are, if unless an exception applies, subject to the Fair Labor Standards Act minimum wage and overtime requirements. The federal and state exemptions, even when they have the same name, are not literally identical. The tests are worded differently, and occasionally that can make a difference. For the most part, an employee who is exempt from overtime under the FLSA is also at least partially exempt under New York law, but there is a wrinkle that if the employee doesn't specifically meet a New York exemption, even though they meet the FLSA exemption, they would still be entitled to receive overtime at time and a half the New York minimum wage. In other words, someone meets the federal exemption but not the New York exemption and is normally paid the equivalent of $30 an hour. If they then work over 40 hours, New York law would require not that they get paid time and a half the 30 hours, but that they get paid time and a half the New York minimum wage. That's kind of a peculiar situation that most people don't know about or don't want to have to deal with, but technically that's the way the law works. Not all salaried exemption employees qualify for exemption. A lot of people equate salary with exempt, but the salary is usually only one component of an exemption, if it's even a component at all. And job duties are usually also relevant to whether someone is exempt. And in that case, it is critical to note that it is the job duties that the individual actually performs and not just the job title that determines exemption status. Under the FLSA, the most common exemptions are the white collar exemptions, which have a weekly salary threshold currently of $684 per week. If you are subject to New York's minimum wage and overtime requirements, you will see momentarily that there's a higher salary threshold for some of those. Note that deductions from salary, such as if the person doesn't work the full week, can destroy the exemption, and in fact can destroy the exemption not only for the employee from whom a deduction is made, but even from other employees in the same job category. There are a bunch of different nuanced exceptions, exemptions under the FLSA that are industry specific that we can't address in this webinar, but they may apply to some employees in your organization. So double check on that. And as I mentioned before, it is possible to be exempt from the FLSA, but not New York law, and how that might create at least administrative and payroll complexity. The major white collar exemptions are the administrative, executive, professional, and outside exemptions, and these exist under both the FLSA and state law, but again, their wording is somewhat different under the various statutes. What I have on these next few slides are the requirements for the New York administrative, executive, and professional exemption. Basically, these are going to generally require non-manual or office-based work that involves some form of supervision or the exercise of discretion and independent judgment. I think most of you are generally familiar with these. I don't want to spend much of our limited time on them. The key point on these is the executive administrative exemptions in New York have higher thresholds, which are increasing for upstate New York to over $1,000 per week for the first time. New York City, Long Island, and Westchester are already at $1,125 a week, which is getting pretty close to twice the federal requirement. The New York professional exemption, which would apply, for example, to doctors, lawyers, teachers, and accountants, does not have any form of salary requirement. However, you would still, in most cases, need to meet the federal salary requirement of $643 per week, except that the federal statute has a specific exception for doctors, lawyers, and teachers who have no salary or wage requirement at all under either federal or state law. Again, assuming they're actually performing those roles. You can't just have someone who happens to have a law degree working for you in some entirely different capacity and then rely on that exemption. The outside sales exemption information is in here. The note here is just be real careful to understand that this is really for outside sales. And that means the person is primarily engaged away from the office or even a home work location. They need to be on site a good portion of the time, making sales, deliveries, pitches. They could be at conventions or trade shows, or they can go door to door. But if they're just sitting in your showroom or call center making sales, they probably would not meet this exemption. The last subject that I want to introduce, and then I'll wrap up with tying it together with some notice requirements, is pay frequency. New York State, as I mentioned at the beginning, has specific requirements on how often private employers pay their employees. This doesn't apply again to governmental entities. There's another category of railroad employees that I'm not going to address here because I don't think it's going to apply to any of you, but manual workers, commission salespersons, and clerical or other employees are the three main categories that might apply. Manual workers have to be paid weekly, except that nonprofit organizations can pay manual workers up to semi-monthly, meaning twice a month. And large companies in New York can get authorization of the Commissioner of Labor to pay semi-monthly on the theory that they have so many people to pay. It's more of a administrative and cost burden to have to do it weekly. This is something that's been litigated recently to say, well, if I wasn't paid within 7 days or weekly, then I had my rights violated. Historically, there's been the argument of yes, but if you were paid, only a week late, you still got the money, so there weren't really much in the way of damages. But courts are now starting to say even this technical violation of not paying on time can result in extensive penalties, including liquidated damages of at least what the person was actually paid anyway. In other words, what they earned but were paid late. And importantly, there can be recovery of attorney's fees in these cases, which has now led attorneys to be interested in filing them. So double check and be careful if you have manual workers to pay them weekly. The Department of Labor says that manual workers are those who spend 25% or more of their time performing physical labor. And this doesn't necessarily just mean construction type of labor or outside labor. I mean, it can be lifting and moving things within, an indoor facility. For example, among other potential tasks, there's not a whole lot of clarification on what is or isn't a manual job, but it is something you should reconsider in light of the wave of litigation and the way the courts are ruling. Commission salespersons quickly are people who are paid primarily based on commissions. For the most part, you can pay them at least once a month, but it has to be in writing in a specific type of agreement that meets certain requirements that the state has. There is an exception here for managerial uh, persons who are paid primarily based on commissions, but you would still want to have that in writing, I think, as well. There's really the catch-all further category of clerical and other workers. This is all employees except manual workers, commission salespersons, railroad workers, and those eligible for the executive, administrative, or professional exemption who earn more than $900 per week. Currently, executive administrative employees exempt under New York law have to receive more than $900 per week anyway. Professional exemption may not require that type of payment. But if someone meets those types of requirements and gets paid over $900 per week, they're not a clerical or other worker. So theoretically, you don't have to pay them semi-monthly. The important note here is that it is possible that someone meets the executive, administrative, or professional exemption, but also qualifies as a manual worker. And in that case, the manual work payment of weekly requirement would still potentially apply. So you could have an exempt employee who still has to be paid weekly. All right, the very last point before we go to question and answer. So if you do have any questions, go ahead and get those in. Is that now that you hopefully review all of your classifications, decide who's an employee, who's entitled to be paid, who's entitled to minimum wage and overtime, and who isn't, make sure it's documented properly. The New York State law for, again, non-governmental employers requires you to give a notice of pay rate to all employees at the time of hire, and then subsequently, if you change the rate of pay, other than in some cases just an increase in the pay rate, this has to be provided in writing. It has to identify things like what the regular payday is and the pay period. So that needs to be documented properly. There are specific fines for not providing that documentation to every employee. So make sure you do that. That has to then be signed by the employee and a copy retained by the organization. If you have someone who qualifies as a student or intern, you should have proper documentation for that. New York State has some specific requirements of what they expect. Regardless, you need to have as much documentation as you can to show that the person really qualifies as a student, what academic program they're involved in, whether they're getting credit, this exact documentation in a specific situation can vary. But if you don't have that type of documentation and someone were to challenge the fact that you weren't paying that person who is working for you, you may not be able to prove that they qualified for a student or internship exception. Wage statements have to be given out every time you pay your employees, and make sure that you're doing that. Normally that's a check stub, or these days an electronic check stub, but that is required. Notice of leave benefits. Again, non-governmental employers are required to have in writing their policies on vacation, holidays, sick leave, other paid time off, and hours. So if you don't have those types of things in writing and made available to employees, then the employee, regardless of what their classifications are, can come back and claim that they were entitled to some of these benefits. So again, these should be benefits likely limited to employees, not independent contractors, and you want to have it in writing so the employee can't just claim they were entitled to something else, where the Department of Labor, for example, will agree with the employee if the employer hasn't specified in writing what their benefit entitlements are. Finally, a termination notice. When you let any employee go, then you need to put it in writing and say, this is when you will receive your final pay, and this is the status of your employee benefits. This is technically a separate requirement from any requirements you have under COBRA to let people know about their health insurance continuation rights. So I normally recommend some sort of termination letter that includes something about, you will receive your final paycheck on this date, or this the next pay date, whether you specify the exact date or not, and that you're no longer entitled to any employee benefits as of this date, sometimes mentioning that you will then also receive separate COBRA paperwork. Again, this is a requirement for employment and a requirement that is not going to specifically apply in the public sector because of the way New York's labor laws are written. Not a requirement that you have to follow or need to consider for your independent contractor relationships. Instead, your independent contractor relationships should have agreements that specify when the um, contract or relationship is going to end, and any provisions on how it can be terminated. And to the extent you're going to address that in the contract, you want to be careful to distinguish it from how you would treat an employment relationship. So you don't want your independent contractor agreement, for example, to have a standard at will employment relationship provision saying that the independent contractor relationship is at will, because that is something that would make it look more like an employment relationship. With that being said, I know we covered a whole lot of material. I'll make the slides available in just a moment. If you have any questions, please type them in so that I can answer those. But follow us on LinkedIn. This is where we post our latest updates, articles, and alerts for employers in New York specifically, although we have information of federal laws as well. Now I'll take questions here. Again, this is not a privileged communication. So if you have a specific situation involving your organization you want to discuss offline, then there is my contact information. I don't currently see any questions. Maybe you're all just overwhelmed by all that information. I'm going to make the slides available and allow a little bit of time. If you have a question, please go ahead and type it in, or at least type in that you're about to ask a question so I know to wait. I encourage you to use these materials in thinking about whether there are aspects of your workforce classification that you need to revisit. Again, they're not necessarily going to replace an in-depth legal analysis, but hopefully they will at least let you know where you might have a question that you need to look into further. Again, I think it's really important to keep in mind the distinctions between for profit, non for profit, public, private, government, non government, because there are different standards, tests, allowances, requirements in those different areas that, especially if you're looking for information online, won't always be specified in the material you're using. Okay, well, at this point, I don't see any specific questions that have come in. I know there's a lot of information crammed into this little over an hour. Thanks for those who were able to stay on a little past an hour. Hopefully, I answered some of the questions you otherwise would have had in that little bit of extra time that I took to present some of the material. Um, I know there is a lot to these issues. Not all of them are relevant to all of you, but any of them could potentially cross your desk in some way, shape, or form. And hopefully, this material gives you a better handle on how to think through those issues, or at least to know when you need to ask for additional analysis. So I will give just a few more seconds. If you're typing a question at the last minute, go ahead and push enter so I can at least see that there's a question coming. Otherwise, momentarily, I will log off. Okay, well, not seeing any questions at this point, I will end the webinar. Thanks again for attending, and look forward to additional webinars from us in the future. If you're registered for this, you will receive notice for those unless you ask not to. And if you are somehow seeing this after the fact and we're not registered, then you are welcome to reach out and we will add you and make sure that you get notified. That everyone have a good day, and I will hope to see you next time.